This is Dr. David Shine, and welcome to Business Law 101. Now, contract definition is not especially exciting. It's a set of promises that are enforceable. And so we're going to talk about some of the function of that. Now, the slide tells you form is usually not important. Technically, that's true. You can write a contract on the back of an envelope. You can have an oral contract that's binding. But the reality is that we're business people. This is a business law course. And so what we want to focus on is most businesses have created standardized contracts that they will utilize over and over again, and their in-house counsel or the outside legal team will continuously work to polish those agreements and, of course, unfortunately, make them longer and longer and longer. And if you've bought or contracted for anything recently, whether it's a cell phone or cable television or a new piece of software, you're aware of the fact that there's all sorts of exceptions and exclusions and disclaimers in the modern contracts that are taken. And so we'll talk some more about that. So the agreement is for bargain for consideration. And what we want to underscore is in the common law, consideration is required for a contract. So if I say, I feel like I'll have you cut my grass, and you say, well, I'll cut your grass, I feel like it. First of all, those are illusory promises on each side. Neither one is binding, but also there's no consideration recited. We're also looking for an agreement between two or more parties. You can't really have a contract with yourself, although you could probably, if you own a corporation or an LLC, which is a separate entity, you can actually contract with your own corporation or LLC. So just a little footnote there. And of course, it has to be for a legal purpose. So how do we get contract law? Well, first of all, going back to the first 6 chapters of the course, remember that we talked about the fact that the United States is a common law jurisdiction. We copied that from the English, and so we follow a system of recorded cases. So these are not codified. They're not based on statutes. However, to expedite commerce among the states, we have the Uniform Commercial Code, the UCC, and in particular, we'll be talking about UCC 2, which is sales, and UCC 2A, which are sales through leases. And that's a very common way that businesses acquire capital goods, is by leasing them in a purchase structure, but it's called a lease, which keeps the biggest part of the debt off their books for accounting purposes. Of course, many people today, because of the high cost of automobiles, are leasing their automobiles instead of buying them. For most individual consumers, unless you are really into having a brand new car every 2 or 3 years, it's often not a good deal in the long term, but that is, again, up to each person's or family's finances. But the UCC is very popular, and there's only one state that does not participate in UCC, and that is the fine state of Louisiana, our neighboring state, because as we talked about earlier in the course, that is still a civil law jurisdiction left over from when the French originally had New Orleans set up, and of course part of Louisiana Purchase. So Louisiana has stayed with the civil law system. And again, as a practical matter, dealing in business between the two states is very easy. So it's not really affected by the fact that there is a situation there where they're technically under a different legal system. So just so you're all aware of that. This is Dr. David D. Shine for Business Law 101. If you've enjoyed this episode, please subscribe on your favorite platform.